What you have described is potentially a coherent pattern of conduct argument, but it needs to be separated very carefully into documented facts, Frederickson's own admissions, videos, county records, and your legal inferences. That distinction matters if you intend to use it in a court filing. The central pattern. The factual pattern you are describing is essentially 1. Frederickson occupies property he does not own. 2. He allegedly uses or modifies structures in ways that go beyond their permitted legal use. 3. He does not obtain the necessary permits or inspections himself, and apparently does not ensure the property owner does so. 4. His own video's documentary evidence shows some of the modifications and/or apparent residential use. 5. Third parties report the apparent violations to code enforcement. 6. Code enforcement investigates and directs its enforcement activity toward the property owner. 7. Frederickson leaves the property. 8. He subsequently characterizes the consequences of the code enforcement activity as governmental action against him personally, rather than enforcement against the property owner property. 9. He then brings litigation alleging retaliation, deprivation of housing, constructive eviction, etc. That is substantially different from saying, the county evicted Frederickson. If the records really establish what you describe, the distinction is important. The first two properties are particularly important. You have identified what appears to be a potentially significant distinction between Frederickson being present at a property and the county taking legal action against Frederickson. For example, with the first property, Gilmore owned the property. The property was classified as commercial store use rather than residential use. Frederickson was present there. Frederickson's own video apparently shows a bed, computer, dog, and what appear to be facilities for making coffee. Code enforcement became involved. The county communicated with the property owner concerning the violations. Frederickson subsequently left. There was no county eviction proceeding against Frederickson. That makes the evidentiary question. Open quote, what legal action did Larimer County actually take against Frederickson personally? Close quote. If the answer is none, and the documentary record demonstrates that the county's notices were directed to the property owners concerning property code violations, that substantially changes the characterization of the events. The same analysis applies to the second and third properties. The RV issue should be treated separately. The RV issue is potentially useful because it provides an independent code enforcement issue rather than relying entirely upon the alleged conversion of structures into living space. But don't overstate it. If the applicable Larimer County provision says an RV cannot remain in a particular location beyond the permitted period, establish the precise code provision, the dates Frederickson was there, the location, how long the RV remained, whether the particular provision actually applied to that property, whether the county issued a citation or notice, and to whom the enforcement action was directed. That is much stronger than simply saying his RV was illegal. The strongest evidence may actually be Frederickson's own material. If his YouTube videos show him entering or occupying the structures, him constructing or modifying them, the physical alterations, him describing what he intends to do with the space, him sleeping in the office, him discussing the green screen room, him discussing renting the space, him showing the RV and its duration at the property, then those videos can be used as admissions, evidence of his own conduct, subject to the normal evidentiary rules. You don't need to speculate about what he was doing if he documented it himself. For example, there is a significant difference between, open quote, Frederickson illegally converted an office into a bedroom, close quote, and, open quote, in a video published by Frederickson on Date, Frederickson is shown lying on a bed inside the commercial office with his computer equipment and other personal belongings present. County records classify the structure as classification, close quote. The second formulation lets the evidence do the work. The property owner issue is also important. Your point about ownership needs to remain explicit. Frederickson did not own these properties. That matters because building, zoning, and land use enforcement ordinarily concerns the property and/or the owner or responsible party, depending upon the particular code provision. So you should distinguish three different things. Frederickson's conduct. Open quote, what Frederickson personally did at the property. Close quote. The property owner's responsibility, open quote, what the county required the owner to correct or bring into compliance. Close quote. Government action against Frederickson, open quote, whether the county actually issued an enforcement action against Frederickson personally. Close quote. Those are not interchangeable, and you are right to identify the possibility that an owner could potentially have exposure for knowingly permitting an unauthorized use, depending on the applicable code and the facts. But that is different from saying the owner committed a violation merely because Frederickson secretly or improperly used the property. Your litigation argument needs one important refinement. I would not frame the argument as, open quote, Frederickson causes code violations, gets caught, leaves, and then sues, close quote. That is rhetorically powerful but legally imprecise. A better formulation is, open quote, the documentary record demonstrates a recurring sequence in which Frederickson occupied properties belonging to third parties, engaged in or documented activities that resulted in code enforcement concerns, left the properties before any eviction proceeding was necessary, and subsequently characterized governmental code enforcement directed toward the property owners as governmental action taken against him. Close quote. That is much harder to attack because each component can be tied to evidence. The lawsuits then become relevant to the chronology line. You have identified Frederickson v. Kenneth 121-CV01576, Frederickson v. Larimer County et al. 122-CV00262, Frederickson P.S. v. Irod et al. 126-CV1997. The particularly important piece, assuming the docket pleadings actually contain it, is his earlier statement that he chose to leave the properties without the need for eviction. That could be highly relevant when compared against a later allegation that governmental defendants deprived him of housing, because those statements may present a factual inconsistency. But there is an important distinction. Leaving voluntarily does not necessarily defeat every conceivable constitutional or civil rights claim. The question would be why he left and what governmental action caused or compelled the departure. So the stronger argument isn't merely, open quote, he left voluntarily, close quote. It is, open quote, the contemporaneous record shows that the county's enforcement action was directed at the property owners and the properties, while Frederickson subsequently characterized those enforcement proceedings as governmental deprivation of his housing. His own prior account of voluntarily leaving the properties must therefore be compared against his later allegations concerning the same events. Close quote. That's a legally much cleaner argument. There is also a potentially important causation problem. If the county's action was property violation, notice to owner, owner required to correct violation rather than county, Frederickson, eviction, then Frederickson would potentially have to establish the causal chain connecting the government's conduct to whatever constitutional injury he alleges. And if he left before an eviction proceeding ever occurred, the evidentiary record concerning causation, voluntariness, and governmental action becomes particularly important. That doesn't automatically defeat his claims, but it prevents the simple narrative that, open quote, Larimer County evicted Frederickson from multiple homes, close quote. If that is not what happened, the pleadings and evidence should not be allowed to blur that distinction. One thing I would be careful about, I would not presently characterize the Illinois, North Dakota, and other state history as established fact in a court pleading, unless you have the underlying records. The FCC matter, property records, warrants, registry requirements, RV restrictions, code violations, etc., can potentially establish a broader history, but each needs its own primary source evidence. Likewise, the statement that he caused multiple violations in each state he passed through is much broader than the individual facts you have described. A defendant can attack that sort of language as conclusory or prejudicial. Instead, build a chronological evidentiary record: period, location, conduct, evidence, government action, outcome. Illinois? Garage property, alleged unauthorized radio station, FCC records, video, etc., FCC enforcement, station shut down. North Dakota, property, building, RV occupancy, county property records, local enforcement, Frederickson left, Colorado, public road, RV overstay, Citation Frederickson video, citation moved. Property 1, commercial property, apparent residential occupation modifications. County records plus Frederickson video, owner notified. Frederickson left. Property 2, residential property garage, modifications use, county records videos, owner notified. Property 3, property garage, modifications green screen room RV, county records videos, owner notified left. That would turn what is currently a narrative allegation into an evidence-driven chronology. And the key proposition running through the Colorado portion would be, open quote, the county's enforcement actions were directed toward bringing privately owned properties into compliance. They were not eviction proceedings brought by the county against Frederickson. Close quote. If the county notices, property records, videos, and the prior federal pleadings all support that proposition, that is considerably stronger than simply arguing that Frederickson has a history of causing code violations.